and this is in the interest of Knight, minor child. Non-custodial party is Vincent. The Lamar Knight. Custodial party is Jessica Humanness, and this matter was originally before the court on petition established parent-child relationship. Court will note for the record both parties have previously been noticed and served. We've been operating under a temporary order in this matter. The court will note for the record further that Mr. Chris Hamblin is representing Mr. Knight. Ms. Humanness is pro se. The court did appoint Ms. Kuzak to go over the requested settlement agreement with the parties and come back to the court and give the court the details of such and confirm that the court can go along with that. Because the court still has to do specific things dealing with the custody circumstances and how they want to try to set it up, and then I'll see what we have at this point as per the agreement. So at this time, I'll ask obviously the state. They brought this matter, so I'll ask the state for an opening to tell the court what the state is requesting we do here today, and then I'll go to the Mr. Hamblin and then to the Ms. Kuzak to tell the court what you understand the agreements at this point are. And again, I'll let the state start out with that, and we'll see, and we'll take it from there. But I'll let the state start out and let the lawyers confirm that that's the agreement, and then we'll get some testimony and we'll get it done. Thank you.
Thank you, Your Honor. So say you understand that everyone wants the temporary order that's in place that was signed on March 24th, 2025 to be mostly finalized as is. With the presumed father excluded like before, child's surname is not going to change. Joint management conservatorship with nobody is no one's primary. They're both they both have the right.
Folks. Okay, here we go. No, we're not going there. I'm sorry. It is my policy always to set someone up as primary because, again, I'm not going to come back in 3 years and have to deal with this again as far as custody is concerned. If we're going to do custody, we need to do it now. I hate to kick y'all out and make y'all do that all over again, but I always set up a primary one way or the other, whether y'all try to do 50-50, 60-40, whatever it is. I set up the right to decide domicile because I'm going to deal with school. And again, and obviously I'm the court of continuing jurisdiction, so it'll come back to me to fix when this child is 4 years old. And I want to do it now. So that, and again, it's absolutely under my rights to do so. So, all right, go ahead and tell me everything else. Let's see what we got, guys. All right, thank you.
Yes, Your Honor. So besides that, there is a jurisdiction of Bell and contiguous counties. Cash medical of $57 starting April 1st, 2025. And then non-disclosure for Miss Humanness was reserved, along with court costs, current child support, and retro that weren't mentioned. Regarding those issues, state asked the court to apportion court costs appropriately. Current child support, the state agrees based on the fact that the parties are having 50-50 possession, and also that they agree on it to set current child support at 0, although the state will still want to figure out what guideline is, even if that's not actually going to be ordered. And then the state's not asking for any retroactive support. And then non-disclosure, the state understands the parties are in agreement for neither party to have non-disclosure. Yes, that's it, Your Honor.
All right, Mr. Hamblin, I'll let you go, sir, because again, the judge is getting ready to try to put a wrench in your agreement. So I understand that's the agreement. So go ahead and tell the court, number one, I need 2 things. Why I should not name a conservator, and I still got to find it's in the best interest of the child that no child support be ordered, and I'm supposed to look at the financials of both to make a determination on whether or not that's appropriate. So go ahead and tell me on both issues, sir. Thank you.
Thank you, Your Honor. Just very quick background. When the parties entered to a irrevocable settlement agreement regarding this issue prior to the temporary orders hearing, and more related to the issue that you're concerned, Your Honor, about the conservatorship issue of naming a primary parent, I kind of expected this issue. And so the parties agreed within that ISA that both parties would be geographically restricted and that the enrollment and the children's primary residence, the address to be used in bookkeeping and school enrollment and medical insurance would be mother's residence. And so they did not specifically state that a parent would be primary with the right to determine the exclusive decision for residence, but that mom's address would be the one to have for enrollment purposes, doctor's addresses, and all the housekeeping things we need. Because I agree with you, Honor, the court does need somebody's named, that there's a black and white, where does mail go to for this child, things like that. So with that note, we've covered that issue, and the parties agreed and they signed to it. And then we think that,
And that includes schooling also? That includes schooling?
That's correct. School enrollment would run off of mom's
Okay.
address.
All right, so yeah,
We don't want to disrupt.
You got me, okay.
Yeah.
Okay, you're good enough, thank you. All right.
So that's that issue, Your Honor, and then they are going to continue to follow a week on, week off schedule, a 50-50. Neither parent will pay child support. We believe that's in the best interest, because if we had a hearing on the merits, I would show evidence of how much money my client has been paying towards the care for the child, and from everything from diapers to obviously rent, ensuring the child has a safe place under the Texas Family Code. And so the parties agree that when the child is in their possession, that they're responsible financially for that child. And so after looking at my evidence in this case, I believe that it meets the best interest standard under the Texas Family Code, that this child would be cared for, and that child support is not necessary or appropriate in this case. However, there is Medicaid in this case, and my client is electing the one to cover that Medicaid to make sure for state government-backed insurance that that's being paid and being paid timely. So he will make sure that that happens. And if reasonable employer-based insurance does occur, that he would have the child insured under his policy. I think other than that, Your Honor, I think that covers it. I can go explicitly into kind of more of the factors if you'd like to. For me, regarding
no, it's not necessary right now. You covered what I was having a problem with, and so we'll get the testimony. And the state has already said they're going to ask questions about income, so we'll get that taken care of in the court and go along with making that in the child's best interest after I get that data, and we'll see about making this a final order. No problem. Are you muted, Ms. Hamlin? Is there anything else you were going to say?
Oh, I'm sorry. No, Your Honor. I think that's all I had for you, unless you wanted me to go dive into other issues.
No, doesn't sound like it. So anyway, Ms. Kuzak.
Judge, I agree with what was said before. I've spoken with the mom and with the dad. It appears that they have been working cooperatively, and that's something they want to foster. I've spoken. They have not done they've been doing 50-50, but it's been kind of also working around work schedules and things like that. I spoke more with the mom on this, probably because, to be honest, sometimes I wonder in some of these cases, if we're hearing some of these things just because it's a workaround for child support. And so I asked about some of these other issues and whether it is pretty close to 50-50. And she said that it is. There are times when they kind of switch off. She needs him to pick up, he needs her to pick up, but they've been working cooperatively. That this is something that she wants to foster also, along with father as well. This is something that has landed in a more healthy place than it was before. And so she wants to facilitate it for that purpose. I would ask, in addition to the language in the temporary orders, I would ask for there to be a specific drop off and pick up time. It just says the father will have possession for a week and they will alternate weeks. So I would like the language that says pick up at mother's house.
Let's get some testimony on how they've been doing it and the time frames and what's they normally do. Because again, it's 6 o'clock on Sunday or 6 o'clock on Saturday. I need to know, because I've used both, obviously. So or 12 noon on Saturday or Sunday. Yeah. Okay.
Okay. And I think they've been also doing at mother's house, which is, the home base, kind of the Belton address for the school. The non-disclosure issue, I think both parties they've represented to me that they do not need non-disclosure at this point, especially considering how cooperatively they're going to have to work going forward on, picking up and dropping off.
Okay.
The no support issue is as both of the attorneys have represented to the court, including the cash Medicaid. The other addition I would ask for is to use AppClose, in case that way there is a clear record if things need to change down the road. If this does not work out, then they have a more printable version than some of the text messages that I've seen as potential exhibits for the court.
Yeah, and of course, Mr. Hamlin, do you have a problem with that? I always like to use the AppClose or a parenting app, because just in case what happened to my brother, somebody stole his cell phone at the gym, which is kind of weird. But the bottom line is, luckily it's all backed up. But that kind of stuff can go bye-bye where everything is always in AppClose. So you have a problem with AppClose?
Not a single objection to that, Your Honor. It's completely fine with me.
All right, thank you. You can go over your client about that. Anything else, Mr. Kozak?
No, Your Honor.
All right, let's get some testimonies from the parties. So at this time, and is it Humanness or ma'am? How you pronounce your last? I've been saying Humanness, I think so.
It's Humanness.
Humanness. Okay.
Yes, sir.
Okay, there was an old TV show where the guy and his name was Jose. That was his big thing. My name is Jose Humanness. So that was long before you, Mr. Hamlin. But anyway, I'll go ahead and have y'all both turn the video and unmute yourselves and raise your right hands and let me get you under oath. The whole truth and nothing but the truth will help you.
Yes, sir.
I do.
Say I will. Okay, I will. I do. It's all good to me. All right, you're both officially under oath, and I'm going to go ahead and let the state call you as witnesses, and obviously the two other attorneys will have the opportunity to ask more questions on their cross-examination, and we'll take it from there. So at this time, Mr. Welch, like I say, this is your bailiwick, so you get to start, sir. Thank you.
Thank you, Your Honor. State calls Jessica Humanness. What is your full name?
Jessica Renee Humanness.
What is the full name of the child in this case?
Camden Lamar Knight.
When was Camden born?
February 21st, 2023.
So how old is Camden?
2.
All right. So to talk about what I'm interested in, what kind of health insurance does Camden have?
Medicaid.
Do you have access to private health insurance for Camden?
No, sir.
Are you all right with the $57 per month that Mr. Knight is paying for cash medical beginning April 1st, 2025 to be finalized as is?
Yes, sir.
Do you have access to private dental insurance?
No, sir.
So how are you currently employed?
At Dillard's.
How much do you make there?
$22 an hour.
Do you have any other children besides Camden?
Yes, sir.
How many?
5.
Are these children biologically yours or adopted?
Biologically mine.
Do these children live with you or do you pay support for them?
They live with me.
Are these children, there's a lot of them, older or younger than Camden?
They're all older.
Are you okay with no current child support being ordered because of y'all's 50-50 arrangement?
Yes, sir.
Do you understand that with no current child support being ordered, that the court may modify this order only if there's circumstances of the child or a person affected by the order have materially and substantially changed, or it has been 3 years since the order was rendered or last modified, and the monthly amount of child support award under the order differs by either 20% or $100 from the amount that would be awarded in accordance with the child support guidelines?
Yes, sir.
And are you asking for any retroactive support?
No, sir.
Do you have any safety concerns with Mr. Knight?
No, sir.
Pass a witness.
All right, Mr. Hamlin.
No questions, Your Honor.
All right, Ms. Kuzak.
Thank you, Judge. Just to clean up on some of the custody issues, your main concern when we talked about this is that you want to facilitate an open relationship between Camden and his father, right?
Yes, ma'am.
You want him to be an involved father, and you want his his help in raising Camden, correct?
Yes, ma'am.
Okay. And so is that part of the reason why you're agreeing to a split custody schedule?
Yes, ma'am.
Okay. You're wanting your house to be the residence for school enrollment, correct?
Yes, ma'am.
And it's basically kind of been the home base. Has he been picking up and dropping off Camden from your house?
Yes, ma'am.
Okay. Would you like that to continue going forward?
Yes, ma'am.
You agree, and we did not really speak about this, but the court typically has, as it shows in the temporary order, a pretty close geographic restriction in 50-50 cases. And so you're asking for it to be, or are you okay with it being Bell and contiguous county?
Yes, ma'am.
And contiguous, of course, meaning the counties that touch Bell County. Are you
Yes.
okay with that? Okay. You and I spoke about how I would like a more fixed start and stop time. And do you think that Sunday is a good start and stop time for visitation? Okay.
Yes, ma'am.
And
Okay,
do you,
and remember, ma'am, you and he could agree to something different, but failing agreement, it would fall back on that time, all right?
Yes, yes, sir.
All right, thank you. Proceed, Ms. Kuzak, thank you.
thank you. And so, and the judge brings up a good point. There have been times when, and so Mr. Knight, is self-employed and a truck driver, correct?
Yes, ma'am.
And so there have been times where, he's had to do a run or something where he's asked you to have possession when it's during his week, right?
Yes, ma'am.
Okay. And so, you guys will need, other than that, you guys will need a specific schedule. And so and you agreed that Sunday at 6 o'clock would be an appropriate pickup and drop
Hey, what,
off.
Ms. Kuzak, let's go ahead and use 12 noon. Let's not get these guys out on I-35 at 6 p.m. They can agree to later, but
Okay.
I'm understanding that he's in Williamson County, and since the judge has to go down to Travis to see his grandkids, yeah, I'm out of Austin by 1 o'clock on Sunday, or I'm not coming home. So,
Okay. Well, and my primary concern, Judge, obviously was just having a specific time
Right.
instead of saying the
yeah,
alternate.
let's use 12 noon. That way we don't have to worry about being dark in the winter and all that other stuff too. So yeah.
Thank you, Judge. Then we've talked about non-disclosure. Do you have concerns for your safety if Mr. Knight has your contact information or your address?
No, ma'am.
And so you're asking for there not to be a non-disclosure. In other words, you guys will each disclose your address and contact information to each other, correct?
Correct.
And I've talked to you about using app close. Is this something that you agree would probably be helpful?
Yes, ma'am.
Okay, are you asking that both parties be ordered to use app close going forward for your primary way to communicate with each other?
Yes, ma'am.
Okay. I pass the witness, Judge.
All right. Anything on redirect, Mr. Welch?
Just only two questions, Your Honor. So Miss Jimenez, what city do you live in?
Belton.
And do you work an average 40-hour week?
Yes, sir.
Pass the witness.
All right. Thank you very much, Mr. Hamblin.
Nothing further, Your Honor.
All right, Ms. Kuzak.
No, Your Honor.
All right, call your next witness then, Mr. Welch. Thank you.
Thank you, Your Honor. State calls Vincent Knight. What
Yes,
is your
sir.
full name, sir?
Vincent Lamar Knight.
All right. So do you have access to private health insurance for Camden?
No, sir.
How about private dental insurance?
No, sir.
Are you okay for this final order to continue to pay $56 per month starting April 1st, 2025 for cash medical?
Yes, sir.
How about private dental insurance?
No, sir.
Are you okay for this final order to continue to pay $56 per month starting April 1st, 2025 for cash medical? Yes, sir.
100%. Yes, sir.
do you have any military or police or otherwise you could call it heroic background?
No, sir.
I'm gonna waive court costs. They're doing the 50-50, so I'll waive court costs. Thank you. You don't have to go down that.
Yes, Your Honor. Do you have any safety concerns with Ms. Jimenez?
No, sir.
And are you asking the court for non-disclosure for yourself?
No, sir.
How are you currently employed?
Self-employed.
So how much do you make approximately how much do you make approximately then?
I think we came up with my paperwork. It's like 700 or something a month, if I'm not mistaken.
Do you have any other income coming to you?
No, sir.
Besides Camden, how many other children do you have?
I have one older child. He's 21.
And I assume that child is no longer in high school?
No, sir. UMHB, Delta.
And what city do you live in, sir?
Round Rock, Texas.
Pass a witness.
All right, Mr. Hamlin, you're a witness.
Thank you, Your Honor. Mr. Knight, you provided your 1040s for 2022 and 2023. Do you remember doing that?
Yes, sir.
And if you recall in those two tax forms, you made roughly about $13,000 a year. Does that sound about right?
Yeah, yes, sir.
And so you are a self-employed contractor. You're in the trucking industry, correct?
Yes, sir.
And so your business makes a revenue, and then you pay your expenses and your bills, and then you take a draw, correct?
That's how it's supposed to work. Yes, sir.
Okay. And then do you think it is in the best interest of Camden that exchanges happen on Sundays at noon? Are you okay with that?
I'm fine with it.
And then do you also think it's in the best interest of Camden that you and Camden's mother operate communication through App Close, which is a parenting-free app?
I don't see a cause for it, but just another app on my phone, I guess, but.
Yeah, but if the judge orders you to use an app,
Oh yeah, no problem.
you will follow the court's order.
Yes, sir. Yes,
Okay.
sir.
Nothing further, Your Honor. Pass witness.
All right, Ms. Kuzak, you're a witness.
Thank you, Judge. Mr. Knight, are you okay with the geographic restriction to Bell and contiguous counties?
Yes, ma'am. Fine.
You've been picking up and dropping off, generally speaking, on Sundays, correct?
Yes, ma'am.
And so does 12 o'clock sound like an appropriate time that you can also facilitate?
Yes, ma'am.
Have you been picking up and dropping off from the mother's house?
Yes, ma'am.
Okay. And do you plan to continue that?
Yes, ma'am.
I have no further questions, Judge. I pass the witness.
All right, anything else on redirect, Mr. Welch?
No, Your Honor. I did want to ask Mr. Hamlin to repeat what he said, that he was. I couldn't hear it well, sir.
He clears about $13K a year.
That's correct.
All right. Is that 13,000 or 1,300?
13,000.
13,013,000 via a 1040. So it has to pay taxes on that.
Yeah.
All right. Thank you, Your Honor. Pass the witness.
All right, then. Anything on technically recross, Mr. Hamlin?
Nothing further, Your Honor. Thank you.
Ms. Kozak?
No, Your Honor.
All right, people, I'll go ahead and make the announcement. I'll go along with the agreement. I'm going to go ahead and name you both joint managed conservators. I'm not going to. I'm restricting the right, the domicile of the children to Bell and contiguous counties. I'll go ahead and say, for the purposes of schooling and medical records and all those other things that come up in a child's life, the mother's address and will be used going forward, either the one in Belton or wherever she moves in Bell or contiguous counties. I'll go ahead and order the dad to pay the cash medical. I'll go ahead and set up the visitation package as far as the exchanges being on Sunday at 12 noon. Obviously, you guys can agree on something differently, especially when it says dad's a freelance trucker. So that that's always a scheduling conflict a lot of times. But obviously, y'all been working through it, and we'll do that going forward. I'll go ahead and order 0 child support based on this circumstances at this time. I'll also go, like I said earlier, waive court costs, set up the exchange. That's to be the visitation, and all other agreements that the parties made here today, the court will sign off on, including the court's ordering that to use app close going forward. Again, sir, it's just every now and then I get into those he said, she said, and the court always goes along with what app close says, okay? Because if you do it through app close, it's always going to be there. Losing the phone, anything like that won't matter. And so it's just a way to confirm what's been going on one way or the other. So at this time, I'm going to ask the parties, do they have any other questions? And then I'll end up with the lawyers. So at this time, Ms. Humanness, anything else? Any questions, ma'am?
No, sir.
All right, Mr. Knight.
No, sir.
All right, Mr. Hamlin,
Nothing further, Your Honor.
Ms. Kuzak,
No, thank you, Judge.
Mr. Welch.
And just for the record, Your Honor, no non-disclosure.
No non-disclosure is granted. The parties are they need to be able to communicate with each other.
And then no retroactive child medical dental supports also granted as well.
Correct, sir.
I think I'm good, Your Honor. Thank you.
All right, then, Mr. Welch. Obviously, you prepared the order, circulated amongst the attorneys, and they'll circulate. Again, obviously to Miss Humanness, because she's our own pro se litigator. I'm sorry, in this matter, and then send it over to me, and I'll sign off on it. Thank everybody very much for working this one out and cooperating and doing what's in the best interest of the little boy in this matter. So, like I said, I'll let y'all prepare that and let everybody get out of here then. Well, I think it started raining outside again, so here we go again. So,
Yes, sir.
Thank you, Judge.
all right, thank y'all, and everybody be careful out there and try to avoid lightning, floods, and everything else you've been putting up with this week. So,
I'm
thank you.
in it.
So,
Thank you, Your Honor.
Yes,
you.
sir, you do.
Thank you, Your Honor.
all right, we're
And-
off the record.
Yeah.
And Mr. Hamlin, Ms. Kuzak, and Ms. Humanness. So yes, I'll be the one circulating the order through DocuSign. I'll put on there technically how much Mr. Knight is making. And you know that there's 0 children outside, but it will still have a deviation language of due to the 50-50 and parties agreement going down to 0. I don't expect it to be an issue, but if y'all have questions, y'all know how to reach me.
Sounds good to me. Thank you so much.
Thank you, Mr. Welch.
Thank you.
Thank you.
Thank
All right.
y'all.
Guess everybody's free to go, and I'll stop YouTube, and I'll see you in the morning, Mr. Welch.
Yes, Your Honor.
Thanks, Judge.
We're fine to leave?
Yeah,
Yes,
everybody's
sir.
free to
Okay.
go.
All right. All right. Thank you.